You know, we're going to talk a little later, and quite soon actually, about the Manafort case and the jury coming back and asking a number of questions. And they asked questions that were really quite astounding and yet very rational. What's a shelf company? You're the prosecutor. You just spent 2 weeks laying out your case. You didn't even define the terms of the various entities that you're talking about. They asked the judge to clarify. The judge says, look, I can't do that. You know, the case has been argued. Both sides have rested. You need to figure these things out. And they asked other technical terms. The prosecution's thrown all this stuff out there. They may still get their convictions here and there. They're on a charge here and there. Their star witness is a disaster. They're telling the jury, no, forget about him. Focus on the document. I don't think these guys are particularly good. All right, now when we return for our third hour, I hope you'll stay with us. I want to talk a little bit about what happened in the Manafort courtroom today. The jurors had a number of questions, not a ton, but a number, that I thought were fascinating. Not to predict an outcome, I'd be foolish to do that, anybody would. But they weren't really clear about a few terms. Especially one that grabbed my attention. I'll be right back. During the first day of jury proceedings, it lasted 6 or 7 hours or so, the jury asked a couple of questions of the court, including what is a shelf company and a few other technical terms. Now, this isn't the question that particularly drew my attention, but still, they're asking questions like that. That means the prosecution didn't explain these technical terms, or some of them. And apparently that phrase was used repeatedly. Again, I'm just giving you a sense. You're sitting in a jury room, and you're asking these things, and the prosecution has to prove its case beyond a reasonable doubt in each one of the charges. Now, they threw a zillion charges at Manafort, so they're hoping they get 1, 2, 3, something. Or all of them. They asked other questions. They said to the court, can you help us organize the evidence as the evidence, the documentary evidence applies to each one of the charges? Can you help us put it in order? The court said, no, you have to do that. We don't do that. We can't do that. That's interesting. Maybe they're overwhelmed. Maybe there was too much thrown at them. Then they asked the judge, and here's the one that got my attention, to define reasonable doubt. What's meant by reasonable doubt? And the prosecution and the defense counsel apparently agreed, and the judge said, well, it doesn't mean there's no possibility whatsoever. It's something less than that. What's reasonable doubt? So they're not, I guess the defense counsel was rather pleased today because they didn't just say, okay, let's sit down, guilty, 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 guilty. They, well, what's this phrase mean, and what's this phrase mean, and what does reasonable doubt mean? And, can you help us take whatever information we're supposed to take and apply it to a particular charge? These are really straightforward charges, but it can get complicated. Bank fraud and tax fraud. Now, here's the truth. What usually happens in a case like this is there isn't a case like this. Because the first thing that usually occurs in this process is there is an extensive IRS audit. It could go on for years. The IRS sits down with your accountants go through everything, the IRS issues their own investigative subpoenas, they gather information, whether it's on wires or whatever it is, wire movement of money and so forth and so on, and it can go in various directions. But typically it doesn't go straight into a criminal prosecution like this. I'm just telling you the truth. There are criminal prosecutions in tax cases and bank fraud cases. That's quite obvious. But typically, it's not the first shoe to drop. And I'll give you further evidence of that. Remember, the FBI was aware of a number of these foreign bank accounts in 2015 and 2016. That's just 2 and 3 years ago. During the course of another investigation. They were aware of them, they asked about them, and they moved on. They moved on. Now that's pretty remarkable, isn't it? If in fact you're talking about these massive sums of money, ripping off the American government, and the federal treasury and so forth, why would they just move on? Why would they slow down and say, you know what, let's really dig into that? But they didn't really dig into that. It's almost as if they dusted off this old matter. They decided to make a bigger push on it because of who Manafort is. Again, I'm no special pleader, ladies and gentlemen. If he's guilty, he's guilty, but that's not my point. And you could tell the judge from day one wasn't really happy about this case. Like, why are you focused on this guy? You're the special counsel. Obviously, you want to beat him down. And keep something else in mind. If they get a conviction on 1 count, 2 count, 10 count, whatever it is, they're still going to go back to the prosecutor and say, all right, give us something, and maybe we'll fight to reduce the sentence. You can still plea, you know. That is, in terms of your sentence. You can still cut a deal. And then you have the other trial hanging over Manafort in Washington, D.C., in front of a liberal Obama judge. So they're thrilled about that, the prosecutors. But what I said earlier was this. Again, maybe they'll get a conviction on all counts. That's not my point. What I said was this. This was a sloppy prosecution. A very sloppy prosecution. If, in fact, the documents are enough to convict, as the prosecution said in its closing argument yesterday. Plus, if you have witnesses, accountants, bank officials, bank employees, and so forth, why would you put Gates on the stand? You knew Gates was going to be filleted. You knew he was going to be hammered. You know he's a serial liar and he's a crook. He even cheated Manafort, his friend and his boss. You know he's a reprobate who has no character. And my buddy Andy McCarthy points out another thing with respect to this guy. What? He says. They were charging Gates with counts that added up to over 100 years in prison. And the deal they cut with Gates is 2 relatively minor counts, a maximum potential of 10 years in prison, with a likelihood of serving no time. You go from 100 years to 0? Well, that should raise eyebrows. You're that desperate to have this witness? Is that equal justice, ladies and gentlemen? No. And yet, defense counsel chewed him up pretty well, really. I think. I wasn't there every day. I didn't hear every argument. Wasn't there any day. So, again, I'm reading the news accounts, some of which are better than others. And you don't get a sense of how the jury reacted, you know, not being in the courthouse. But it's very interesting to me that the jury comes back with a number of technical questions. Well, what does this mean? What does this mean? Well, these shove corporations, I won't say that was the heart of the case, but it was certainly significant. You're setting up these companies in order to, they argue, launder money through them overseas. What's a shove corporation? And what's reasonable doubt? And how do we match up all this evidence with with the various charges? How do we make sure this evidence applies to this charge and so forth and so on? So, I don't know what to make of this other than, and again, we don't know. But if you're the prosecution, you have to be a little nervous. If you're defense counsel, you have to be not happy, but you have to be somewhat pleased, because it's up to the government to make the case. The government has to make the case. It's not up to the defense to make the case. The government has to make the case that this guy committed these serial crimes. He did it with intent. And the test is reasonable doubt. Reasonable doubt. That's the test. I'll be right back.
Mark Levin.